Good afternoon, everyone. It's a pleasure to have you on our immigration webinar today. My name is Bernard Wolfsdorf. We are talking about President Obama's immigration executive action, and we have an all-star cast today, including none other than the famous Carl Shusterman, Shusterman.com. Carl is a walking encyclopedia and certainly the best immigration website in the history of immigration websites. If you haven't been on board, go to Shusterman.com, but I'm sure you've all been there. And folks, by the way, this is my competitor. So when I'm saying this kind of thing about my competitor, you got to know he has to be good. So Carl Shusterman will talk to us today about DAPA. Carl is a former INS trial attorney himself, so he certainly knows the name of the game. And I think we just had a little technical snafu right there. Anyway, we have our tech man right here and ready to help us. I'm also killing a little bit of time. We had about 700 people registered for today. And so the Carl Shusterman will be talking to us about the important topic of DAPA. People who have been a child are going to be eligible for some form of relief. Carl will fill us in exactly what kind of relief, what this means, and with his vast experience, particularly in the area of removal, he'll fill us in on all the minute details. Be sure immigration will make this. How do I know this? Well, I've been practicing immigration law for 3 years, and there's nothing they can do without making it complicated. I've already seen some cases which really are quite perplexing. In addition, we have Richard Yemm. Rich is a certified specialist by the State Bar of California. Rich about waivers, the all-important topic of obtaining relief for second preference. Finally, none other than Joseph Shepard, an attorney with our office, is going to address aspects of this legislation. Unfortunately, aspects are relatively underdeveloped. Only time will tell exactly what benefits we'll see. I certainly hope it's not going to be like the Entrepreneur in Residence program, where there was a lot of, frankly. The other thing is we are going to be doing a monthly, I repeat, a monthly immigration. Generally speaking, we will take the second Thursday of every month, so mark your calendars for January the 8th, lucky 8. We will have new speakers. Hopefully Mr. Shusterman will participate. In order to reach Carl Shusterman, go to his website at Shusterman.com. If you want to reach us or our attorneys, go to Wolfsdorf.com, or you can even email us ryemm@wolfsdorf.com, jshepard@wolfsdorf.com, or bernard@wolfsdorf.com. We look forward to hearing from you. So to take it away, we have Mr. Carl Shusterman leading. And Carl, thank you so much for being with us today.
Bernie, it's a real pleasure to be here. Bernie and I have been practicing together. I mean, technically we are competitors, but we really help each other when the chips are down. So it's really my pleasure to be invited today. We're going to go right into the new DAPA program that started on November 30th with President Obama's announcement. soon as we, okay. So this is, and my picture up there, we did a couple of years ago when DACA is the Deferred Action for Childhood Arrivals. When that program came out, Congresswoman Janice Hahn had me down in her district to do a seminar, and that's the picture I decided, because it looks like DAPA is sort of the child of DACA. So let's just move right along. DAPA if you haven't heard this acronym, it's called the Deferred Action for Parental Accountability. Now, a lot of people I see on the message boards all the time, they're saying, the DREAM Act passed, what benefits do I get? Remember, this is not a DREAM Act. This is not a law passed by Congress. In fact, the GOP in Congress seems to be very upset about this. This is something that is an executive order by the president, and what you have to bear in mind if you're going to apply for this is that whatever information you give to the government, I don't think it's going to harm you, but when a new administration comes in, it's anybody's guess what they're going to do with that. It is something that various presidents from Ronald Reagan onward have done, which is to give prosecutorial discretion to certain people who might be here unlawfully, but there's only so many people that the president can deport every year, and President Obama has probably deported more people in the last 6 years than all previous presidents. But that's about 400,000 people a year, and this program is estimated to be helping 4.4 million parents of U.S. citizens and permanent residents. Now, I've heard over and over again in the press that this does not lead to a green card. Not necessarily, but let me just tell you, I might get the interest of a few people who this will benefit, but I do free consultations at a lot of college campuses for the DACA kids, and a lot of them have gotten advanced paroles, which are international travel permits to go abroad. If they came into the United States initially illegally, but now they get an advanced parole and they leave and return to the U.S., and let's say they marry a U.S. citizen, they can adjust their status and get a green card in the U.S. because they're on the DAPA program, something that they cannot do right now. So do keep that in mind. Now, who does it apply to? So as I said, it's parents of U.S. citizens and permanent residents. It freezes on the day that Obama's announcement came out. So that was November 20th, 2014. So if you had a child, doesn't have to be a child, you could be 80 years old and you could have a son or daughter who is 60 who has a green card, and you would qualify for this. But if they got the green card on November 21st, or you had a child in the U.S. on November 21st, 2014, you do not qualify. Now, one thing that is a problem is that this program doesn't take effect immediately, so there's going to be a lot of regulations, a lot of clarifications, and as Bernie Wolfsdorf has warned you, the government is going to make this complicated. They always make this complicated. I worked in the government in the late 70s, early 80s, and I remember I'd have to spend weekends reading all these regulations to get it in my own mind. So one question I decided to put up is, what if you're a step-parent or an adoptive parent? You know, Obama didn't go into that kind of detail. I would think both classes would qualify. A step-parent would be somebody who marries the biological parent of the child before the child's 18th birthday, and an adoptive parent would be somebody who adopts the child before the age of 16, and the child's in their physical and legal custody for at least 2 years. When does the application period start? The administration saying within 180 days. So I just went to the calendar and said May 20th, but that's actually about 183 days. It'll probably be early or mid-May. So many of these rules have yet to be published, so how can we do a seminar so early on? Well, my experience in immigration law tells me that a lot of the rules are going to be the same as the DACA rules. So we're going to go over the DAPA program, the DAPA program, with a lot of the rules that apply to the DACA program. And if they change, we will update this in a later seminar. But a lot of people would be wise to start preparing the paperwork right now. So I think it's important to have this seminar in December like we're doing. So who's eligible to apply for the DAPA program? Number one, you have to have resided continuously in the United States since the beginning of 2010. You also have to show that you were physically present in the U.S. on November 20th, 2014, and please don't leave the United States between now and the day you submit your application, because you'll disqualify yourself from eligibility. And you must show that you were unlawfully present in the U.S. on the day that Obama made his announcement on November 20th, 2014. So you could have been unlawful because you came in to the United States illegally. You could be unlawful because you overstayed a visa. And where the DACA program diverges from general immigration law is they don't recognize what we call visa violators. So if you're on a student visa and then you work but nobody knows about it, you may not be qualified for this, but we'll have to discuss that when regulations or clarifications come out. I shouldn't say regulations because it won't be a regulation, but when clarification comes out on from the government. Also, President Obama mentioned that there is a requirement that you learn English. Now, there's 4.4 million people that are actually qualified for this. There will not be very many interviews, if any. So how will the Immigration Service know whether somebody learns English, and how much English will they have to learn? Again, coming attractions. However, another problem is under the DACA program, if you committed a felony, a significant misdemeanor, or 3 or more insignificant misdemeanors, you're not qualified. And I think the standards are probably going to be the same for DAPA. Also, President Obama made a distinction that although you must pay taxes going forward, so get ready, by April the 15th to pay your taxes next year. But if you didn't pay your taxes in previous years, you may have problems with the IRS, but you should not have problems qualifying for this program. Now we get to the point, and I put in this folder here because I do have some clients who come into my office with these folders and have all the evidence I need from step one, which means they probably could have done the case by themselves if they're that organized. But 90% of my clients are not that organized. I'm not that organized in my personal life. Luckily, my wife is an immigrant from the Philippines, and she is the organized one, so I don't have to worry about it. But remember, you're going to have to prove that you have this continuous residency from before January 1st, 2010 until the present. And my best guess is that immigration is going to want to see official paperwork at least on a monthly basis that you were in the U.S. I mean, you can have other kinds of proof, but there's nothing that talks as loudly as official proof. So what do you want to get? You want to get your work records. If you're paying into Social Security, you can order now, before the big rush starts, something called a detailed earnings statement. You can bring your state and national income tax returns, medical insurance, visits to the doctor. If you've been going to school, you can bring school records. If you've been getting mail and it has your name and address with the date stamped on it, then you can bring those type of records. You can bring your phone bills, checking and bank accounts. There's really no limit to what you can bring in, but just keep in mind that you have to show month by month that you were in the U.S., and the Immigration Service is going to get some fraudulent applications by people that are pretending that they have been here when they really haven't. So they're going to look at these with a skeptical eye, so try to be very, very careful about it. Now, let's say, just for an example, that you were here starting in 2007, but in the summer of 2010, you just can't seem to find any paperwork at all to show that you were in the United States. In this case, under DACA, and I'm assuming it'll be the same for the DAPA program, you can use affidavits to close the gaps. Richard Ramirez was present in the U.S. between July and September of 2010, and it should be very detailed. This is how I know this. You know, we used to go on fishing trips together or whatever it was that you did together. But if it's your friends or relatives, immigration's going to be skeptical about using those affidavits. So what I would recommend is try to get affidavits from people in a position of authority. You may want a religious leader like a priest. You may want a teacher if you're going to school, because you know they're just going to be skeptical about friends giving affidavits. Now, another thing that a lot of people really didn't think of, especially people like me who are in their 60s, but I'm, as Bernie Wolfsdorf pointed out, I am on the internet a lot, probably too. My wife calls herself a web widow, so maybe a little too much. But everybody seems to use social media. You know, even attorneys from our firm, we go out to lunch and they'll be texting or getting a message from their spouse or something like that. And usually these social media things have dates on them. So if you do have a period of time where there's a gap where you can't show you're in the U.S., you may be able to go into your Facebook account or some other LinkedIn, some other social media, or even emails to show you were in the United States. My best advice is start collecting all of this now. I mean, all these slides are important, but this is the slide that's probably important to everyone. So that's why we're having the seminar in December. You have 6 months to start gathering this information, so let's do it now. So let's get into something that I hope most of you don't have, but if you do, the laws or the rules about criminal convictions are quite different from the usual immigration law. For one thing, we have a lot of people that are undocumented and they're driving because they got to get to work, take their kids to school, and they've gotten tickets for driving without a license. Under DACA, that is not considered a misdemeanor, and I expect this will be largely the same. Also, under the regular immigration law, if you have a conviction expunged, it's still a conviction. Under DACA and hopefully DAPA, and I'll stop saying that, I'll just call it DAPA, but you know what I'm talking about. Expunged convictions do not disqualify you. It's like not a conviction at all. However, the government says if you were in a gang or you're a safety threat to the community, which they'll decide on a case-by-case basis, even if you don't have a conviction, they can exclude you on criminal grounds. What's a felony? Well, you may have gone through a criminal procedure and your lawyer said, oh, you have to plead guilty to a felony or something, but it's probably under state law. Here we're talking about a federal policy. So a felony is only a crime that you were convicted of if the term of imprisonment exceeded 1 year. That's the possible term of imprisonment, not what you got. And on a significant misdemeanor, they're actually very specific. So if you smacked your spouse and got convicted of a domestic violence crime, that is a significant misdemeanor. You will not qualify for this unless you get it expunged or vacated. Also, sexual abuse or exploitation. If you have a burglary conviction, unlawful possession or use of a firearm, drug distribution or trafficking. And here I have to stop for a minute because you notice it doesn't say drug possession. So if you were picked up for possession of marijuana, possession of cocaine, whatever it is, and this will not prevent you from applying for DAPA. However, also in contravention of the regular immigration law, if you were convicted of driving under the influence of either alcohol or a drug, you are not eligible for this program. So if you have a crime like that, you really have to go out now and get it expunged. Also, any crime for which you were sentenced for over 90 days is considered a significant misdemeanor, and you don't qualify for the program. Now, here's a complicated area which I have to necessarily condense down to one slide, but a case that went to the Supreme Court around the time that I started as an immigration lawyer for the INS, called Flutie versus Rosenberg, said that some absences from the U.S. are considered brief, casual, and innocent. And take me at least an hour to go through all of this, so we're just not going to do that today. But if you've had absences from the U.S. within the last 5 years, you have to talk to a lawyer and see if it can be classified as brief, casual, and innocent. If so, you qualify. If not, you do not qualify. Now, pretty plainly, if you were deported, excluded, or removed from the U.S., and you are now in a foreign country, that is not a brief, casual, and innocent departure. How about if you were removed and you came back again? Another subject that we could take a long time to talk about. If you went out of the U.S. for an unlawful purpose, doing a drug deal, some kind of crime, then you're definitely not eligible under the DAPA program. How about the forms? When I grew up, I think a lot of young people haven't heard about this, but since this seminar is for, or at least my part of it is for parents, maybe you've heard of a singer named Graham Nash, who, by the way, one of my friends, Fred Benson, represented him, and he became a U.S. citizen a few years ago. But he had a very famous song in the 60s called Immigration Man, and we loved it, those of us who were working for immigration. And he talked about immigration forms, and the rhyme was, immigration form big enough to keep me warm. That is no joke. I mean, it sounds like one, but when I first worked for immigration, the citizenship form, the naturalization form, was 4 pages, and it cost $15. These days, it's 21 pages and costs $680. So that's the way things are going. The form for DAPA has not been issued yet. However, you will have to submit an I-765. You get a work permit that's good for not 2 years, but now it's been increased to 3 years. It's not automatic, though, so you'll also have to do a 765 worksheet. The cost of that is $465, and that will determine whether, even though you are qualified for DAPA, whether you get a work permit. I talked before about going from DAPA to a green card, and for that you would definitely need to get a travel permit. I put AP, which stands for Advanced Parole. Sounds like something a little criminal, doesn't it? But all it is a work permit. And if it's like the DACA program, you'll be able to apply if you're going abroad for educational purposes, to attend classes at a university in a foreign country, if you get a temporary job in a foreign country, or if your grandmother or your aunt or some close relative is in serious medical condition, you may be able to get a humanitarian parole, and that would be $360 for that application. Now, a lot of people aren't aware of this, but what if you are presently in removal proceedings? Can you qualify for DAPA? And the answer is absolutely you can. So I actually have one person who I never talk about, and I'm certainly not going to say her name today, but the government started trying to deport her in 1985, and we're just about to hit the 30th anniversary of this. We've been fighting out her deportation case. When I got the case, she was unmarried and no kids. Now her kids are college graduates, her husband's a citizen, and I can't wait to call her up and start her DAPA application, because the fact that she's in removal proceedings, and actually her case is not before a judge or the Board of Immigration Appeals, it's in the federal courts. But that doesn't matter. She's in removal proceedings, and she is very eligible for this. So if you're in removal proceedings, we put a link on our website. I'm sure that Bernie Wolfsdorf probably will do the same, to ICE's website, the Immigration and Customs Enforcement Agency, and they give you a procedure, complicated I must say, a procedure for how to get your proceedings closed so you can apply for DAPA. You know, I did say in the past that, you know, if you have really good records and so on, you may be able to save the attorney's fees and do this on your own, and I would encourage you to do that. But if you're in removal proceedings and you want to do this on your own, you're really shooting yourself in the foot. I mean, it's complicated. You have to deal with the government attorneys. Make sure you get a good lawyer to negotiate with you. How about if you're in detention or you have a relative who's locked up by immigration and you're eligible for DAPA? Maybe even you were under a removal order from years ago and they just caught you a week ago or a month ago, and they have you in jail trying to deport you to your country. If you qualify for DAPA, they can't deport you. But, you know, in the last bullet point, you know, take a look at my page and Bernie's page, and there'll be a link to show you how to go to ICE and get your case closed. And this is my final slide. What happens? Well, let's say you do this on your own, or do it with or immigrate, any program where there's 4.4 million people who are going to benefit. Everybody sees dollar signs. You know, attorneys see dollar signs, and these other people see dollar signs. But, you know, you want somebody who's really experienced to do this. You don't want to do it on your own. But, you know, having said this, people are in different financial shape. You do it on your own or with one of these people, and it gets denied. Can you appeal it? No, you can't. There are no appeals. Can you reopen it and say, oh, well, you know, I didn't put in this affidavit and I should have, so that would change? Can't do that either. Under the DACA program, they made one minor exception to the fact that you can't do motions to reopen, and that was if the Immigration Service actually sent an RFE, which is a request for evidence, an old address, and you didn't get it, and then you found out later that your DAPA got denied because of that, then you can ask them to reopen it. But in closing, the best strategy is to have a good lawyer, but if you do it on your own and it doesn't work, you do reapply. So make sure if you don't do it right the first time, do it right the second time. You'll have to pay the fees all over again. And with that, I wish you good luck. The next two speakers will be talking about other aspects of President Obama's new program.
Carl, thank you for that excellent and informative presentation. In order to reach Carl Shusterman, you can simply log on to his website, which is shusterman.com. Carl Shusterman is probably one of the most seasoned immigration attorneys in the entire United States, extremely well respected here in Los Angeles as a source of information. And for those of you who want to receive updated information, I encourage you to sign on to his newsletter, one of the most informative newsletters. As this program unfolds, we will see numerous memos, coming out with additional guidelines. Carl, of course, has gone into the weeds already on some of the topical issues. Certainly if you are in proceedings or if you have a final order, this matter becomes quite complicated, and certainly you need counsel. I would argue that the very nature of this program, one would want to seek out and obtain expert assistance. I have somewhat of a humorous dispensation, and I was just thinking with Carl when he was talking about stepchildren. Of course, a stepchild, several of the people who've called me have been here without status for years and years, and unfortunately have not had any success with breeding. No children. I, of course, have 4. Carl has a stepson, however, so he qualifies through that route, and no doubt that brought to the attention the fact that you do need to have a child if you're going to qualify for DAPA. On the other hand, if you marry a U.S. citizen who has a child, your timing is good, so the market is definitely there. If you were about to propose, it's time for a trip to Tiffany's and go get that ring, because the question is, did you have to have a stepchild as of November 20th? Is it too late to marry your live-in? At this point. Interesting questions, but certainly some that went through my mind. The other question with the DUI, those of us in California live in constant fear of the California Highway Patrol, the chips, and oh my gosh, there's very few people I know who have not been stopped by the CHP, and certainly the question of fortunately, my wife took away the car keys last year, so I didn't get one, but certainly a lot of people do have DUIs, and it appears that an expungement may work. I'm not yet convinced that expungement will work. This appears to be discretionary, but certainly this is the time, maybe if you do a quorum nobis and the case is reopened with post-conviction relief, but certainly not all expungements are going to work. So certainly those are the areas. And then the most valuable thing that Carl gave us, which he sort of all packed in one little slide, was the critical nature of putting together the support documentation. That big folder that he had, I do think it's going to be very, very important to document your case well. I think that apparently the document mills are already starting to run. With the amnesty program, we saw they were selling document packages. I caution all of you, there's no protection. Please make very, very, very good care to ensure that all the documentation that is submitted is authentic, because we're going to probably see a trade in fraudulent documents as well as bad cases. So for those of you who are lawyers, screen your cases well. For those of you who bump into a document procurer, please be careful, because I have no doubt the Fraud Detection and National Security Unit, FGNS, will be very active in reviewing phony cases to weed them out. So with no further babble from none other than Bernie Wolfsdorf, let's take our certified specialist, Rich Yemm, who will discuss the expansion of the Provisional waiver program, the I-601A program, which was introduced for spouses of U.S. citizens. Rich, explain to us why this is so important and who's going to benefit from this program. Take it away, Rich.
Will do. Thank you, Bernie. Hope everyone can hear me okay. First thing I was going to start with is just a little bit of housekeeping before we really get into everything. This webinar has actually been approved for continuing legal education credit, CLE credit, by the State Bar of California. If you are not attending this webinar live but would like to apply for this credit, you're going to have to email the verification code that you will hear at the end of this presentation, along with the webinar title, your name, State Bar jurisdiction, and your state bar number to webmaster@wolfsdorf.com. The certificate will then be emailed to you. I just know we have a lot of people logged on. A lot of them are attorneys, and if you're looking for the CLE credit, that's what you have to do. Anyway, moving straight on. While DAPA has clearly been the headline of this recent executive action announcement, the less well-known, but we think equally important, the expansion of the Provisional Waiver Program, which is definitely something that we're all very excited about. To kind of explain how this program has expanded, we really do need to kind of go through exactly what the program is and kind of figure out from that side of things where we're going. Let me see here. Okay, so basically the Provisional Waiver Plan or program exists for the relatives of U.S. citizens or permanent residents who cannot apply for their green card or immigrant visa here in the United States. Now, this is particularly important, especially for those who entered without inspection, crew members, other individuals that basically, in order to apply for a green card, they may be relatives, they've got that side of things going for them so they can apply for an immigrant visa, but they cannot apply for the actual green card step within the United States because they have to leave to go through this particular, to apply abroad. The problem comes in the sense that when they actually leave the country, you trigger either a 3-year or 10-year bar. Now, this depends on whether you've overstayed or been unlawfully present for more than 6 months, in which case it's a 3-year bar, or if you've been unlawfully present for more than 12 months, you're talking 10-year bar. Now, this is a bar to being able to come back into the country, and is obviously massively problematic because you may be eligible for an immigrant visa otherwise. You may be a relative. You leave the country, this bar kind of triggers. You're not going to be able to come back in until that bar is done. So basically, the I-601 is what we used to have, and we still have it. It still exists. But it used to be the only option for pretty much anyone in this situation. And what it entailed was you would have to actually go, you could file the initial application, you'd be filing the immigrant visa petition and that side of things here in the US. Once it was approved, you would have to go abroad to go apply for your immigrant visa to be added to your passport, to apply for your green card at the embassy abroad. And the problem was, in this situation, you'd have to wait. Basically, when you went to the interview, the officer would say, look, you've triggered this bar, you're now inadmissible, you need a waiver. So it wouldn't be until that point, when that finding of inadmissibility was made against you, that you could even file your waiver. Now, these waivers can take a very long time. I mean, we're seeing, I think I was looking at case status processing times recently. We're seeing somewhere 4 to 5 month range. So what this meant was a lot of people would have to go abroad, they'd apply for their immigrant visa, they'd apply for the waiver, and they'd basically be stuck abroad until this waiver was approved. And, these waivers require extreme hardship, which we'll go into a little bit later, but the waiver itself, it's not necessarily an open-shut case. It's very subjective. It comes down to showing this extreme hardship to particular qualifying relatives in the U.S. If it doesn't get approved straight away, they often will send out a request for evidence, which takes more time. All of this time, you're outside of the country, basically waiting. And this was this kind of uncertainty. Will they actually even approve it? When is it going to be approved? When am I going to be able to come back into the country? All of this kind of thing was very much the issue. Because the only way to actually apply for this waiver was to actually leave the country, trigger the bar, basically place yourself at the mercy of immigration, and only when you actually had an approval could you come back in. A lot of people weren't doing this. They were just saying, look, no, we're going to stay here in the U.S. And wait it out. So January, March 2013, the 601A was announced, and this is a different kind of a waiver. The 601 still exists for people that are unable to apply for this particular, the 601A, but the 601A only waives the unlawful presence bar, which is triggered when you leave the U.S. and you trigger the bar because of either a 3 or 10 year, either the 3 or 10 year bar. Now, the 601A, the good thing about this side of things is that by waiving this and being able to apply for this while in the United States, you get a decision before you actually have to leave and go off to apply for the next step. Now, one thing that's very important to know is that the 601A does not waive the permanent bar. Now, this is the bar that applies when you've had unlawful reentry after unlawful presence or after deportation. It also only waives this unlawful presence ground of inadmissibility. It does not waive any other ground of inadmissibility, so if there's any kind of criminal issues or fraud or anything else like that, this isn't going to help you. But for the people that it does help, it's definitely useful. So basically the 601A would basically only apply to immediate relatives of U.S. citizens. So you would file the I-130, the immigrant visa petition here in the U.S., you'd get a decision on that, then you would go abroad, then you would file for the 601A, the provisional waiver here in the United States. When you got a decision, you would leave, go to apply for your immigrant visa at the embassy or the consulate abroad, but you would already have that kind of approval of your waiver when you're going. The 601A basically required that you demonstrate that your absence from the United States and from your relative is going to impose extreme hardship to either your U.S. citizen spouse or your U.S. citizen parent. So it's very restricted to those particular categories. But yeah, like I mentioned, you could apply here, you get the decision, you leave the country, as long as the embassy or consular officer does not find you to be inadmissible on a different ground of inadmissibility that isn't, just this unlawful presence side of things. The idea would be you could go somewhat safe in the knowledge that, this is going to be approved, you're going to be able to come back. I'll go into briefly kind of what is this extreme hardship. Now, hardship, this is actually the definition that they've kind of established, and it's not a particularly helpful definition. It's basically hardship that is unusual or beyond that which would normally be expected. Now, the idea is basically that immigration understands that if there's ever any kind of separation, family separation, that's going to cause hardship, ordinary hardship, whatever that means. Now, in order to be eligible for this waiver, you have to show extreme hardship, which has to be this kind of over and above and stronger than what would ordinarily be the case. And the factors that the immigration considers when they look at, what is hardship, what counts as hardship on this side of things, is basically we're looking at kind of health is probably the primary factor that they're going to look at. They're going to make sure that this extreme hardship in the way of medical conditions, psychological conditions, any kind of disorders on that kind of thing. We've done a lot of these cases with, post-traumatic stress disorder, depression, treatment from cancer, severe allergies. This kind of thing can all kind of put you into this class of over and above the kind of ordinary hardship, and it kind of puts you into this category of more fragile individuals that are going to suffer from this higher standard of hardship. Financial considerations is something else they look at. This can be if the U.S. citizen is going to kind of lose employment, lose their business, lose house, lose finances, all of this kind of thing. Same with education, if they're going to lose particular opportunities, personal considerations, special factors, all of these things are relevant, and all of them are factors that immigration is looking at when they're determining whether something qualifies as extreme hardship. But remember, this is only hardship to the qualifying relative. If the foreign national themselves is going to be experiencing extreme hardship, that's not really something that they're going to consider, unless you can somehow show that because the foreign national is going to suffer extreme hardship, the the U.S. citizen spouse or something like that is going to also, be worried or kind of increasingly depressed on that side of things, and you can somehow kind of bring it through that. When it comes to extreme hardship, one of the things that's always good to look at, and one of the things that immigration will consider, is both, the extreme hardship if the U.S. citizen and the foreign national traveled abroad. So they basically both relocated abroad so that they could continue to be together. In the alternative, there's also extreme hardship if separation has to occur. If one person is going to leave, the other person is going to be here. That's also going to be something they're going to look at in terms of extreme hardship. Now, the types of evidence immigration always looked at on these kind of things include affidavits, which are always very useful. This from the person suffering the hardship can work, from family members of the individual, the qualifying relative that we're looking at. Medical documentation, medical, psychological evaluations, these are all very useful types of evidence that are really going to be looked on and given particularly substantial weight. Expert opinions, evidence of employment, business ties, evidence of monthly expenditure to show that, without the foreign national's salary or if they were forced to relocate, the language barrier, these kind of things are going to be standing in their way and not allowing them to actually continue to make a living and to support themselves. Country condition reports is another one that often comes up through the Department of State. You can show that the country that you'll be relocating to, for example, I think we've seen some situations where the qualifying relative in the United States is suffering from a severe form of asthma, for example, and if they were to have to relocate to this particular country, it's going to cause severe issues and severe difficulties on that side of things. And the other thing they're going to look at is proof of family ties to make sure that they are actually your relative, and you're kind of ready for that side of things. So, what has actually changed? Well, the expansion of the 601A, which is scheduled for early in 2015. I mean, basically, a new memo was actually released about the same time as the president's speech that basically is directing the U.S. Citizenship and Immigration Services to issue new regulations and policies with respect to expanding the 601A. Now, obviously, this isn't there yet, and we're going to see more on this within the next 2 to 3 months, but this is going to come, and the idea is that this is going to be expanded to include spouses and children of lawful permanent residents and adult children of U.S. citizens and lawful permanent residents. Now, the idea is going to be that they're going to expand it to proving, you're going to be able to show that there's extreme hardship to a U.S. citizen or a lawful permanent resident spouse or parent. So this is actually big news because this is going to mean a lot of people in the past who were unable to show that they would qualify for this waiver are now potentially going to be included on it. And moving swiftly on, because I know we're short on time, the new guidance that was released by immigration also talks about how they're going to issue new guidance on what extreme hardship really means, which is actually going to be very useful because they're actually going to hopefully go through the factors in a lot more detail so that, again, people, when they're applying for these hardship waivers, will have more of an idea as to whether they have a strong case, whether this case counts as extreme enough, whether they're going to be able to get this waiver and be able to travel and get a green card and go down that way. There's also, in the memo, one of the other things that we're excited about is it does hint at presumption of extreme hardship in certain situations. Now, this isn't necessarily something that new. Such a presumption was previously adopted by regulations under the NACARA, the Nicaraguan Adjustment Central American Relief Act. But if there's some kind of presumptions in this, then it could be something that we would be able to say to people, and you'd be able to see straight away, look, this person has got this particular hardship, therefore we're going to get a positive decision on this, and at least give you a better sense as to kind of going in, knowing that this is strong enough, this is going to work, and we can move forward. And that's my last slide. So I think we'll be moving on to Joseph Shepard, who's going to address the business immigration action side of things.
Thank you very much. Thank you very much, Rich. I'm going to be covering the effects that the President's decision will have in the business immigration context. I'm going to talk about some of the various specific things that we can expect in the next couple of months, and then some of the more broad, less defined categories which will be occurring really with no set time period announced. But some of them are expected to happen around March or April, some in May, some it's absolutely uncertain. But I'm going to go with in order of what I think is the most immediate, will have the most immediate impact in the business or employment-based context. Let me just move along. So here's an overview of the items I'm going to speak about. The various memos that were put out by the White House and then DHS, and then specifically with USCIS in mind and ICE and the Department of Labor, who will be putting out either further regulations or policy memos, talked about some of these key things. There's really 9 things that I want to talk about. The first is we can expect either this month or next the long-awaited final rule granting work authorization eligibility for certain spouses of H-1B workers. Currently, H-4, the category for spouses of H-1B workers, and under this new rule, which is going to be coming out very soon, they will be able to apply for EADs. And as we talked about earlier, EADs are employment authorization documents. Another thing that we'll be talking about are the L-1B specialized knowledge intra-company transferees. At current, many employers can testify to this, that there's a lot of uncertainty right now in the L-1B visa petition context. There's a very high RFE and denial rate at current, which has increased significantly in the past few years. This, or rather, this action was a direction to have USCIS publish their consolidated guidance on their policy, on their interpretation of what specialized knowledge really means. Those 2 items are the ones where we can expect the most immediate changes to happen. So we'll get into detail in a second, but then the other items that we're going to discuss that are a little less firm in exactly what the specifics will look like, but I will go through what we know, are the reform to the STEM OPT, that is OPT, optional practical training for international students who are in the STEM fields, which is science, technology, engineering, and mathematics. Another exciting possible change will be the reform to the visa bulletin system put out by the Department of State and the corresponding changes that USCIS will put into place as a result. Also changes to existing guidance for national interest waivers in the adjudication process and trying to promote that category, second preference category, for wider use. Also involved will be parole for certain entrepreneurs, researchers, or inventors. A direction to the Department of Labor to review the PERM regulations to bring it up to speed in more modern times. And finally, an increase in the portability for individuals to change employers if they have long pending green card cases. So, our first topic, the EADs for H-4 spouses. So in May of this past year, we saw a proposed rule which said that the certain H-4 spouses who will be eligible to apply are those whose H-1B spouse is either the beneficiary of an approved I-140 petition or they're the beneficiary of an approved H-1B petition based on AC-21. AC-21 is a provision that permitted H-1B workers to have their status extended if, in part, the visa category for which their I-140 was filed is currently not able to be used because of the visa backlogs, and they've had either the PERM or the I-140 pending for at least 365 days, before their 6th year maximum of H-1B status. So in other words, before the 5th anniversary. This is a small category in the proposed rule. There were some comments from organizations like the American Immigration Lawyers Association asking USCIS in the final rule to open this up more. There's no reason, for example, to limit the H-4 spouses to just this small category when L2 spouses and E3 spouses, E1 and E2 spouses all have unrestricted eligibility to apply. Some of the other questions that may change between the proposed rule and the final rule, which will be coming out soon, are whether or not it's going to allow the H-4 spouses to immediately apply once these conditions have been met, rather than being able to show that the H-1B petition based on AC-21 allowed and approved, etc. What we do know is that the final rule will be coming out in the next month or so, which will have more details. And in our next webinar on that second Thursday of the month, which, mark your calendars, that's January 8th, Thursday, January 8th, 2015. Hopefully we'll have some updates on specifically which group of H-4 spouses will be eligible. That being said, currently the form that's used for this is the same form used in the DACA or DAPA processes, the 765. The current government filing fee for, this is assumed, it's going to be the flat 380 as opposed to the 380 plus the 85 biometrics fee. That's all subject to change and all subject to the final rule once it's published, but we can expect that coming out either this month or perhaps in January. And I went backwards. Here we go. So the next big area that we're excited about is finally getting some consolidated guidance on USCIS's current interpretation of the term specialized knowledge. Right now, L1 visas are the temporary work visa that can be used by multinational companies and corporations to transfer either key executives, managers, or those employees who have specialized knowledge. As you can see from this chart and from that second bullet points, the RFE rate is absurdly high at current. Only 5 years ago, the L1Bs, the specialized knowledge visa petition category, were only about 20% of them were receiving denials. Now we have RFE and denial rates well above that and double that in the California Service Center. The trend is troubling, not just for immigration attorneys, the foreign nationals, but especially the companies who can no longer, or really at current, cannot rely on this as a possibility for their key employees. There's a lot of mistrust in the L1B, visa adjudication process. Employers hopefully will see some clarifications on this. The regulations right now define specialized knowledge as either special or advanced, as you can see there. And that seems okay. Perhaps that's easy enough. But in reality right now, in the way that they're being adjudicated, USCIS is asking for things like copies of major, any published material by or about them in trade publications, major media, or awards that they've won, or patents that they've been responsible for. Literally laundry lists of things that seem to change on a case-by-case basis. Hopefully we'll have some concise and consolidated guidance on what USCIS actually wants to see for this category. The current state of L1Bs is so rocky that it's hard to imagine that this could get worse. So look forward to that coming out in the next month or so as well, on that consolidated policy guidance. So one of our other options that were, or rather, initiatives that the President announced and DHS is going to implement are the expansion and extended usage of OPT for graduates and students in one of the STEM fields. We expect USCIS and ICE to publish updated rules. Our understanding is they've been directed to work together to issue proposed rules expanding the fields for which can qualify for the STEM designation, and just for explanation purposes, why that's helpful is right now if you graduated from, say, a bachelor's program or a master's program, in one of these STEM fields, and you would normally get your 12 months of OPT. If it was in one of the STEM fields and a number of other conditions are met, you might be eligible to apply for the 17-month extension of your OPT. Well, this kind of directive for them to work together and issue proposed regulations asked them to, USCIS and ICE, to explain what other fields may be able to be used for this, or in what other contexts could STEM graduates benefit, or maybe would they be able to get longer than a 27-month STEM OPT work authorization. So no time frame was provided for the publishing of these rules. Overall, whenever the announcements were made, it was generally implied that 180 days we would see most of these things put forth, but there's really no clear sense of whether or not and to what extent this is going to happen within that time. So stay tuned as things progress. One that I'm pretty excited about is the modification to the visa bulletin system. The Department of State has already agreed that it's going to modify the visa bulletin, and USCIS is working with them, and they will issue updated regulations, proposed rules, etc., based on these modifications, with the goal of facilitating those with approved I-140s to be able to apply for adjustment of status earlier. Now, there were a number of suggestions and arguments to be made as to how they can go about doing this. It's unclear yet whether or not this is going to include the idea of ceasing to count derivatives against the annual cap of immigrant visas. This was put forth right now. If you're waiting in line for your immigrant visa category, and let's say it appears you're number 3 in the wait line in your category to be able to apply for adjustment of status, that may not be the case because the 2 people in front of you may have a spouse and 10 kids, or 1 spouse. So it's hard to determine at current really how long the wait line is going to take. So the idea was to stop counting derivative family members, spouses, and children against the annual limitation of immigrant visas. We don't know if that's going to be the provision or if they would simply just make everyone current, bring every category, every country current, just to increase demand and allow people to apply. It remains to be seen how they're going to do this, but this is expected to impact potentially 400, maybe 500,000 people, and allow people to file their AOS applications sooner. The benefits of doing so are great because it allows not just for the ability to apply for EADAP combo cards while you're waiting. It also would allow you potentially, and this is another thing that's been proposed, to be able to port to another employer if your adjustment of status application has been pending for more than 6 months, as long as it's in the same or similar occupation. I'm going to get to that same or similar in just a moment. This is an exciting initiative announced that USCIS is going to be proposing regulations that will have a new category of parole, either for parole into the U.S. from abroad or parole in place if they're already in the U.S., for inventors, researchers, and founders of startup enterprises who may not yet qualify for, say, a national interest waiver, but they have some ability to either create jobs or facilitate new technologies in the U.S. or generally spur economic development. The requirement is either that they've been awarded a, quote, substantial, unquote, amount of U.S. investor financing, or that they otherwise hold the promise of innovation and job creation through the development of new technologies or the pursuit of cutting-edge research. So no time frame was provided, but again, this is expected sometime before the end of the summer in 2015. Apologies for that. But it will explain more in detail the process by which people could apply for this. This is done in tandem with another initiative which will explain and provide more precise guidance on how these same type of individuals, entrepreneurs, inventors, researchers, etc., maybe who are not in the traditional academic sense in a research position, but perhaps are, can benefit, have a substantial impact on the economic benefits to the U.S. In another way. And so we're going to get some updated guidance on the national interest waiver adjudications for more economic-based type of applicants. But for those who may not qualify for this, they've already said that they'll be able to apply for this type of parole, this new category. So it seems that regulations are going to be forthcoming, proposed rules about this sometime in the next 6 months. Stay tuned and check back as we continue to progress. But nonetheless, this is a very exciting initiative in that it brings forth a new type of category for people who potentially maybe have a significant amount of U.S. investment in their startup or enterprise, but may not otherwise qualify for the investment-based visa, the E2. So it's exciting. Stay tuned on that one. Oh, that looks like the end of my slideshow. I think we may be out of time, is what that means. But just very quickly, some other actions that have been discussed. Like I said, the national interest waiver. The Department of Labor is reviewing the PERM regulations, and there we go. And the same or similar, I wanted to briefly mention. So USCIS said they're going to issue guidance on what same or similar means, so that individuals who have AOS applications pending for more than 180 days and want to switch jobs may be able to do so more easily. Right now, if you have an I-140 approved and your adjustment of status has been pending for over 180 days, and you move to another same or similar occupation, what does that same or similar mean? Well, it could mean a number of things right now because there's not really coherent and concise guidance on point. So we will see. Lastly, we're going to have some recommendations coming out from DOS and DHS on modernizing both the non-immigrant visa application and immigrant visa application process. That's expected 120 days after the announcement. So in March, we should be getting those. Stay tuned for more. For those of you who are interested in obtaining the CLE credit, we are going to give you the email verification code. So if you're not attending this webinar live, but you'd like to apply for CLE credit, please email verification code 4206. 4206, along with the webinar title, your name, the state bar jurisdiction, and state bar number to webmaster, all one word, webmaster@wolfsdorf.com, and a certificate will then be emailed to you. So thank you all very much for your attention today. I am going to see if any of the other panelists here want to add any closing remarks. Thank you for your attention and time.